To date in BSB 111, we've really been concentrating in terms of the law on contract and deals between parties. In this next little module, we're going to move from the relationship between the parties to how that contractual relationship between businesses and consumers is regulated. And this is where we deal with consumer law. There's two purposes for this. One is to give us a better understanding of the law around a lot of business, which is contracts. So it is about the legal element. The second thing, though, is to see how we have those common law elements we've been dealing with thus far in the last 3 weeks. And now we're going to layer over it a piece of important legislation. So we get to see the interaction between common law and legislation, which is how our legal system works, as you'll remember from the first part of the course. So let's get into it. Australian consumer law. There are 4 key areas that we're dealing with consumer law. This little podcast will give us an introduction to those 4 areas, but then we're going to look at misleading and deceptive conduct. We're going to look at unconscionable conduct, and you'll know we've run across that before as part of consent, but this is the legislation surrounding unconscionable conduct, particularly those involved in consumer transactions. We're again going to look at consumer guarantees before finally dealing with manufacturers' liability. So they're the 4 key areas: misleading and deceptive conduct, unconscionable conduct, consumer guarantees, and manufacturers' liability. At the end of this, we hope you'll be able to understand the operation of consumer law and apply the law in those 4 specific instances to some problems. We have some readings, page 318 to 342 as the slide says. Now, how about a bit of background around consumer law? So the main problem here has to do with the change in society around business. So when the common law was developed around contracting, we'll remember the principles of freedom of contract and caveat emptor or buyer beware. And that worked pretty well when people could inspect the goods, deal from the same position of power, and freely enter bargains. But we're in a very different world now, the kind of world where we don't know what's in a product as to whether it will work or not. And we also have large corporations, large organisations that can do something that's called standard form contracting, which means they basically give you a contract. When you go to get a mobile phone, they give you the contract, right? And you essentially take the deal or not. There's no bargain. There's no changing the terms in that transaction. And so what's driven the change in our legal environment is a recognition that the ordinary consumer is no match for these corporations and smart business people who have a lot at stake in making these negotiations as favourable as possible from their angle. And so what we've done is develop, or what society has done, is developed a series of legislative requirements around deals between consumers and business to govern these situations and to mitigate some of the problems that can occur due to the strength of negotiating power and the superior knowledge that business people have. Because without this kind of legislative intervention, we're going to end up with some of the problems that you can see on the left of this slide. Misrepresentations, people saying something that isn't, unconscionable conduct by the businesses, defective products that people can't actually understand as defective till it falls apart on them, and the use of that negotiating or monopoly power in certain situations. So we want to mitigate those problems through a form of legislative intervention around consumer transactions. This hasn't happened overnight. While we deal with one particular act here, the Competition and Consumer Law Act, which is quite recent, at least in legal terms, there have been a series of acts over time in various jurisdictions, including the UK, the US, and each of the states. There was a major piece of legislation in Australia called the Trade Practices Act, which governed much of this area, that's been in place from 1974. But one of the problems was Well, can you think of what one of the problems was? The problem was that the Trade Practices Act was a Commonwealth piece of legislation, so it could only deal with businesses that fell within the powers of the Commonwealth government. Now, you'll remember when we did our constitutional section that the Commonwealth can't make powers for everything. So what we had were different states with different state acts, Fair Trading Act, the Sale of Goods Act in Queensland as well. And then we had this federal piece of legislation, the Trade Practices Act. And depending upon your business legal form, so for instance, if you're a corporation, then the Commonwealth tends to be able to make laws to do with corporations, trading and financial corporations. So the Trade Practices Act applied. But if you were a sole trader, then the Trade Practices Act didn't apply. But if you were a sole trader who had to do business across state borders, then the trade provision of the Constitution said that the Constitution applied, so the Trade Practices Act applied, as well as the Sale of Goods Act. So you can see it was very confusing which act applied, what was the law, etc. And that's been now consolidated into the Competition and Consumer Law Act, which is the same act at the federal level and in each state jurisdiction, so that the law now is uniform through these acts that might apply through different jurisdictions to different types of businesses. But it's overcome the problem of conflicting law through having mirrored legislation in each of the states and at the federal level. We can see that set out in this slide. Since 2011, we've had this single consumer law. It's a single national consumer law set out in Schedule 2 of the Competition and Consumer Act. It's administered and enforced by the Australian Competition and Consumer Commission, the ACCC, and the various state and territory consumer protection agencies. In Queensland, that includes the Department of Employment, Economic Development and Innovation, Fair Trading. So the Australian consumer law is really about protecting the interests of consumers and stopping those unfair practices by any businesses. It's trying to stop unconscionable conduct, misleading and deceptive conduct, and unfair contract terms. It's also trying to provide a minimum level of guarantee for consumers so that if they buy any goods or services, that it's really going to say it will meet the minimum standard required for what they were purchasing it for. We'll go into more detail about those minimum guarantee levels. There is also a specific requirement that manufacturers are responsible for the goods that they introduce to the market. Now, because it's the Australian consumer law, we've got to work out what is a consumer. And here we find that it's defined within the Act, within Section 3 of the Act. Let's have a read of what it actually says. It says a person is a consumer if they've acquired goods or services for less than $40,000. So anything less than $40,000 is a consumer transaction. Or if it's more than $40,000, then the goods or services are of a kind ordinarily acquired for a personal, domestic or household use or consumption. So what does that actually mean? Well, it means if you buy $50,000 worth of dishwashing liquid, right, then that can be a consumer transaction. So it's $40,000 or goods or services of a kind ordinarily acquired for personal, domestic or household use. Or the goods consisted of a vehicle or trailer acquired for use principally in the transport of goods on public roads. So if you buy a car or trailer primarily to transport goods on public roads, then that's going to be covered. But, and here's the big but, the goods or services have not been acquired for the purposes of resupply or for use in a manufacturing process. Okay, so let's take an example. If you buy $39,000 of dishwashing liquid, okay, definitely caught. It's $40,000. Not only, it's under $40,000. Not only that, but it's goods ordinarily acquired for personal, domestic, or household use. The only problem you'll have is if you're going to resell that dishwashing liquid. If you've bought, dishwashing liquid to resell, and it could be $20 of dishwashing liquid to resell, then you won't be considered a consumer because the goods or services were acquired for the purpose of resupply. So hopefully you can see the steps here in a consumer. You've got to work out, is it $40,000? Yes, prima facie consumer. No? Okay. Were the goods ordinarily acquired for personal, domestic, or household use or of a kind ordinarily acquired for personal, domestic, or household use or consumption? If yes, prima facie consumer transaction. If no, so it's more than $40,000 and not personal, domestic, or household use or consumption normally, then no, it won't be covered by the Act. Or if it's a vehicle, okay, so vehicles are separate. So vehicle, ordinary domestic or household use, $40,000, under $40,000. Any of those three, prima facie consumer. Then I need to ask a second question. Have these goods been acquired for resupply or use in a manufacturing process? If the answer to that is yes, if they have been purchased for that purposes, not a consumer transaction. If the answer is no, it is a consumer transaction. You really need to go through those steps for anything we do in this area. It's the first step to recognise whether the consumer laws, as we will deal with them, apply to the transaction